Insurance companies oftentimes will put an extraordinary amount of time and money into defending your injury claim. They know by doing this, they may have to pay out less money for legitimate injury claims. I am fully aware of these practices. You see, earlier in my career, I worked as a lawyer on behalf of insurance companies defending injury claims in court. Let me tell you the story of my past client, Chad. Chad's case involved a car accident case, but the lesson I'm about to teach you with his story applies to all types of personal injury claims, including slip and trip and fall injury cases, dog bite injury cases, and any other type of personal injury claim. Chad's case was referred to me by another injury lawyer so I could file a lawsuit on his case. You see, Chad was in a two-vehicle accident in a rural area on a two-lane narrow road. The facts were disputed, but it was our position that Chad was traveling on the narrow road when the other driver attempted to pull out onto the narrow road to make a left turn in front of Chad's approaching vehicle, crossing into Chad's lane of travel. The other driver apparently jerked his wheel to the left in an apparent attempt to re-enter the parking lot. Chad braked and veered to the left to attempt to avoid the collision. However, the other vehicle's passenger side struck the passenger side of Chad's vehicle. Chad was in the left-hand lane, the lane the other driver was turning onto when the collision occurred. The other driver's insurance company denied liability for the accident. They claimed Chad caused the accident, claiming Chad was driving at an excessive speed. It also claimed that had Chad maintained his lane of travel, the collision would have never occurred. The other driver's insurance company spent a lot of time and money defending Chad's case. After I filed the lawsuit, the other driver's insurance company hired a lawyer to defend the claim. We answered written discovery questions sent over by the defense lawyer. The other driver, through the assistance of the defense lawyer, answered written discovery questions I sent to them. The defense lawyer took Chad's deposition. I took the other driver's deposition. The deposition of a witness who heard the accident but did not see the accident was also taken. A mediation was held, but the case still did not settle. We got a trial date in the case set for a week in January of 2021. I took the video deposition of one of Chad's treating physicians to be used at trial. The insurance company for the other driver hired an accident reconstruction expert to reconstruct the accident in order to have them testify in the case. We filed several pleadings required by the court prior to trial. However, unfortunately, the trial had to be delayed. Due to COVID, the court was shut down in January of 2021. We were informed by the court of this in December of 2020 at a pretrial conference after we had done almost all the work necessary to get the case to a trial. We got another trial date for later in 2021. By that time, we had proven to the insurance company we were willing to take the case to trial. Then, out of nowhere, before the trial date in 2021, we got a more reasonable offer from the insurance company to settle Chad's claim. We negotiated some back and forth, but eventually we were able to reach a fair and reasonable settlement. I fought hard for Chad. We showed the insurance company we were more than willing to take the case to trial unless we get a reasonable offer for Chad's injury claim. We weren't going to back down. We would only settle for a fair and reasonable amount. We had prepared the case for trial. This forced the insurance company to spend a lot of time and money defending the case. Because we prepared to take Chad's case to trial, the insurance company knew we meant business. If we were to get a judgment against their insured for an amount over and above the insurance company's last offer, or even worse for the insurance company, if we got a judgment against their insured driver over and above the policy limits, the insurance company would have been possibly facing insurance bad faith claims, which are separate claims that could have been filed in court directly against the insurance company for acting in bad faith and not making a fair and reasonable offer in a timely manner. We put pressure on the insurance company. By preparing the case to go to trial, this finally forced the insurance company's hand to make us a fair and reasonable offer in Chad's case. We proved we were willing to fight to get Chad a reasonable offer. By doing so, while it took a considerable amount of time, effort, and cost, we were able to get justice for Chad. The thing is, you don't always have to prepare your case for trial. In some cases, you actually should consider settling your injury claim fast, shortly after your accident, long before you get close to a trial. And in this video about to pop up here, I'll tell you the circumstances under which you should consider settling your injury claim fast after your accident. Lastly, if you've been injured in a car accident, slip or trip and fall incident, or dog attack incident in Kentucky, remember to don't wait, call Tate.